Good afternoon. May it please the court. Whenever we rose for lunch, we were looking at the actual judgment of the court, because that obviously forms the centre of gravity around which all the submissions which I make turn. There's only one other paragraph I think I want to show the court, and it arises from how the appellant has put his case this morning. At various times this morning, the appellant has put its case in a way that seeks to criticise the respondent in reasonably trenchant terms. The court will have its own view about that, but it's probably useful, I think, to understand what the judge made of this. And if we look, please, in the main bundle, page 85.
He made a number of comments. He made a number of comments through his judgment.
He did, and I'm not going to pick up on them all. It's fair to say that the judge criticised Mr. Carl in relation to some procedural matters, and I completely take that on the chin. But whenever it comes time to assess the costs, it may be that the court, given some of the case law, including the case from last Friday, which I'll come to in due course, will be interested in understanding the extent to which how my client, Mr. Carl, gave his evidence and how he presented himself to the court compared to the defendant, because obviously some of the case law turns in a situation where both parties have been in some way misleading. And so that's why I bring you to paragraph 142, page 85. And I'm not going to make a very big deal out of it, but it probably is sensible that the court understands the court's findings in terms of the evidence. So the judge said, Mr. Carl gave his evidence clearly and well, and was in my view an impressive witness. He's clearly devoted many years of his life to pursuing the vehicles of which Mr. Edwards sought to deprive him, and his detailed research, ... was both thorough and comprehensive. He cross-examined the witnesses who did appear with tact and sensitivity, and at times exhibited a great deal of self-restraint. I note that a good part of the evidence put forward by Mr. Hawkins and Mr. Howarth was liberally laced with unevidenced personal allegations against Mr. Carl, ranging from dishonesty to deceit to fraud. Mr. Carl sought at one point to introduce evidence to rebut these allegations, a request which I was obliged to refuse since they formed no part of the case before me. However, I can say that having considered these allegations with the benefit of the documentary evidence before me, they were entirely unsupported, should never have been made. It is difficult to constrain a litigant in person in the oral presentation of their case, and I must content myself with finding that Mr. Carl's conduct has, on the evidence before me, been blameless throughout. So, as I say that, I flag that for two reasons. Firstly, because of how the case has been put this morning.
Yes.
And secondly, because, as this court knows, when you come to assess the costs, whether or not there's pot calling kettle black or not is a relevant consideration. So I turn from that, my lady and my lords, to look at what happened and what went wrong at the eventual hearing to decide the costs and so on.
Yes.
There is a little bit of a run-up to this, and it's a relevant run-up, and I hope the court will see that I'm not going to show you anything that isn't of direct relevance. One point which is of direct relevance is the fact that there was a skeleton argument served. It's just it was served by my client. That skeleton argument is in the what we have come to call the unagreed bundle, tab 3 of the unagreed bundle, and tab 3 starts at page 17. Couple of things to say immediately. The court will have picked up that the eventual hearing on the consequentials was in January 2025. My client served his skeleton on the 11th of October 2024. So in other words, even my mathematics can work out that's approximately 3 months before the hearing itself. So the suggestion that you heard this morning of, well, there was no real need for a skeleton, nobody thought of a skeleton, is just not accurate. There was a skeleton, it was a skeleton that was served by my client. There's a couple of relevant bits of the skeleton. A lot of it is irrelevant to today's hearing, but if I just may show you the relevant bits and then make a few submissions on them. The first relevant bit is at page 36. It is sensible, I think, to start at page 35 to see the heading so you can understand where page 36 fits in. under permission to appeal, the respondent began at paragraph 93 saying, although this element of my submission may be premature, I thought it would be useful to provide this statement of my intent to the court and my adversaries to consider or not to do so as they may deem useful. And then over the page at paragraph 95D, here, the respondent said, I may ask for permission to appeal the court's rejection of my claim against Mr. Lambani based on the apparent lack of weight given to repetitive hearsay evidence of Mr. Lambani's involvement in efforts to sell my 959 and RS lightweight and alleged luxury auto collection. And then this bit that the court might find relevant. But only in the event that Mr. Lambani is granted permission to appeal the court's denial of his application for costs. So, certainly in the skeleton received approximately 3 months before the hearing, my client had flagged up what on the face of it looks to be a mistaken view, that at that point permission to appeal would be needed to appeal the court's denial of the application for costs. The second bit of the skeleton, which the court might find useful, is on a few pages at pages 38 and 39. Under 38 and 39, you can see that my client deals in terms with the court's preliminary view on costs in relation to the appellant. And it says in CJ at paragraph 431, the court points out I've made an offer of settlement to Mr. Lambani, ... Then he says, I would respectfully suggest that Mr. Lambani, D9, did not achieve a result better than my settlement offer, and therefore at least a partial award of indemnity costs against him may be appropriate, despite my not having secured a money judgment against that defendant. So he deals with that, and then he also deals with the prior cost award at paragraphs 110 onwards, and he deals with that at paragraphs 113 and 114. Now, why am I showing this to the court? Well, I'm showing it to the court to let the court assess what has been said about the points which the appellant now says it would have argued at the subsequent hearing, and looking at the transcript. And the court's obviously going to have to work on the basis of what counsel tells it about that. But the court will note that some 3 months or so before that hearing, a skeleton argument had gone in from the respondent, which, as I say, at D appeared to suggest that the respondent thought permission to appeal would be needed to overturn the cost order. And then at paragraphs 108 and 109, perhaps pulling the other direction in that, puts forward an argument saying, well, I should get some costs because of the previous offers that were made. So that's the entry point into the hearing that then happens some 3 months later. As the court is aware, no skeleton was served by the appellant for that, notwithstanding, and this is why I wanted to show the court this skeleton, notwithstanding the fact that my client had served a skeleton which, as I say, in one bit appeared to suggest that he was labouring under a misapprehension that permission to appeal was needed, and in another part expressly made an argument to get the costs on an indemnity basis because of previous offers that had been made. Notwithstanding that, no skeleton served from the other side, no indication from the other side, whether in correspondence or anything else, that they intended to make any submissions to overturn the preliminary view, overturn is perhaps the wrong word, to address again the preliminary view which the learned judge had expressed in his judgment. That skeleton having gone in about 3 months before the hearing, making the points which it made.
Sorry, so just to be clear, nothing even to say, hang on, Mr. Carr, you're labouring under a misapprehension here.
Nothing whatsoever to say that, my lady. Nothing to Mr. Carl, nothing to the court, nothing. What did happen on the day of the hearing is, notwithstanding my client being a litigant in person, an hour and a half before the hearing commenced, the appellant served a new bundle of documents. That bundle of documents is also in the unagreed bundle at tab 4, beginning at page 42. Begins at page 42 with the letter. Page 43 is the index, and it may be enough to simply point out that what the index contained was various emails backwards and forwards, some of which have been shown this morning. A skeleton argument from my client requesting a notice of discontinuance, and then at section 2 some of the orders from the court, and in section 3 one case, that being Barton against Wright Hassel. So in other words, not a single document relevant to any of the findings which the court had made about the appellant's liability for costs or otherwise. Not a single document, well, save for the offers, and I'll come to that in a second. That was obviously going to be used in terms of liability for costs, but nothing to do with any of the findings which the court made.
Now, I also understand the point about there being no skeleton, but the argument of we should get our costs is not something that would ordinarily be run off the back of new material being filed for a consequentials hearing, would it? It would be run off as a matter of law and the findings in the judgment. What material could probably have been put in on that point? Authorities, I suppose.
Well, one would have thought authorities, and there is an authority put in. Listening to how the points were put this morning, I would have thought one of two things. Either something to go to the findings that were made themselves. There's clearly nothing about the underlying chronology of the court's findings about that. Perhaps documents which went to the points that were made this morning about us not having made a specific disclosure application. It's difficult to know quite what they would put in it, my lord. I entirely accept that. But it's entirely clear when you look at the bundle and then you look at how it's put.
Well, certainly the authority put in is about litigants in person and behaviour. It doesn't go to the points we've heard discussion about this morning.
That's absolutely right. And when you look at the transcript, as we will do in a second, you can see that's exactly what it was for. The learner junior on the other side made the point in the hearing, well, that's what the Barton and Wright Hassel case is about, is to show that litigants in person are to be held to the same standard.
Absolutely.
And as you can probably tell from my skeleton, that's not a point I rail against at all. Of course they should. But the point is, whenever you are assessing what went wrong in this hearing, it is of relevance that there was a skeleton argument filed, albeit by us. It's of relevance that it appeared to flag up a misapprehension by us as to whether or not we needed permission to appeal or whether it was all up for grabs. It contained material in which we, having said that, then do try and argue about the costs in the skeleton, saying, well, they've failed to beat an offer, we should get indemnity costs. No skeleton comes back from the other side. All the material that goes in doesn't go to any of the points which it is now said would have been made. Again, that's the entry point into the transcript of the actual consequentials hearing. And members of the court, you will find that in the supplemental bundle starting at page 27. Again, it seems apparent to me from watching proceedings this morning that the court has already looked through that in some detail, and so I will not take up a lot of time with the court in doing so. But if we start, it starts at page 27. The relevant portion of it starts at page 35. from page 34 up to, well, down to the bottom of page 34, Mr. Williams, who had been previously acting on behalf of the appellant and another party, makes it clear that he is only there on behalf of the appellant. Then the relevant portion starts at page 35, line C, where he says, I do not think, inaudible, I suspect you will only hear me at the end. My lord, I know you will know what my arguments are likely to be. They are very narrow, and you will not be hearing much from me. This is not my fight to have in the moment, my lord. And the court replies, no. And the learned junior says, I'm literally going to sit back. I'm the last defendant with the narrowest point. I hope that assists you. Now, of course, we cannot know now what exactly was in Mr. Williams' mind. But what we can do is construe the transcript from the perspective of the court. And I say that the court looking at that transcript would not at all have understood that the submissions that were going to be made to it were submissions going to the heart of the cost order against D9.
But the points in play at that hearing were not just cost points, were they?
No, they were not. That's
correct.
There were
points as to the formulation of the order, points as to interest, obviously costs arguments as well, and permission to appeal.
Yes.
And it's fair to say those points as to the formulation of the order and what relief should be granted and in respect of what cars were matters that Mr. Limbani wasn't at all interested in, was he?
I agree. Don't get me wrong, I'm not trying to, I hope the court doesn't think I'm trying to overplay this. There was a whole sequence of points which Mr. Limbani did not wish to say anything about. But equally, the points having been raised in the skeleton argument by Mr. Carl that he wished to revisit the cost order, root and branch, and or perhaps thought he needed an appeal to do that, are not ones that are flagged up. Okay, I can't put it higher than that now. Until we go to page 44 of the transcript. And I know I'm jumping ahead, but I know the court's read it, and I think the court will realise I'm not jumping ahead unnecessarily. So the learned judge says, shall we now deal with Mr. Limbani? Mr. Williams, what do you want to say? So for the rest of the page, Mr. Williams, on behalf of Mr. Limbani, deals with the point which had been raised in the skeleton about offers having been made and not beaten. It's not clear from the transcript whether what is being asked for is an order coming Mr. Limbani's way. That, when you read the transcript, that's not very clear. But what we can see is these submissions are being made in response to a point made by my client about offers and that he thinks he should get costs as a result of the offers. So he deals with that then, and then we get to page 45, paragraph D, where Mr. Williams says, the reason I raised that at page 24, my lord, I know you're aware that there are cost consequences, and you would not have known this, my lord, at the time when you gave your judgment. There are cost consequences for A, failing to file a pre-action protocol letter in accordance with the rules, more so any letter, and furthermore so when you fail to comply with the pre-action whatsoever. And then there's a little exchange in that. And then from H onwards, the appellant's counsel says the cost consequence for failing to comply with the pre-action protocol, as we all know, deal with the prejudice it causes and almost a punitive aspect. My lord, I help you with this. My lord, I do not seek the costs. I do not seek the cost consequences be varied in the totality of give us all our costs for the failure to comply with the pre-action protocol. I say in the circumstance having to catch up with the set-aside judgment, etc., and also not complying, my lord. I ask that they are, and I do this in the most minimal way to be fair to Mr. Carl. I say they are capped at 5,000. The cost for failing to comply with the pre-action protocol, my lord, I am being very kind. Then the court says yes, and Mr. Williams says, it's a matter for you, my lord, I'm not horse trading. I could have asked for 10 or 15 or 20. I'm doing it as a de minimis to note the court's disapproval of not even writing an email. D. Sirs, these are the issues. My lord, can I deal with the simple issues, please? And then the simple issues are all points of detail about previous cost orders.
Now, logically, this ought to have been a fallback argument.
If they had intended to come and argue about the main event.
Against that, we have all in our time walked into court in the face of a provisional indication, not always confident of our ability to persuade the judge to
always confident of that, my lord.
And so maybe the view is, well, let's start here, see how it goes.
Well, it probably doesn't matter. Let me be clear at the end point. I strongly suspect, well, the end point is that for whatever reason, the judge ended up taking the view, my view is not provisional. And so all of this is directed to the question of lack of justice of that. And the outcome is, I'm long enough in the tooth to know that the outcome is very likely to be, and if it is, I'm not going to push too hard against it. This court is now going to consider the submissions that would have been made and to see whether or not there has been manifest unfairness by considering the effect of that. And if that's where the court gets against it, I said before lunch, I'm not going to be unrealistic about that. Because something did go wrong. My submission is really a very simple one. It's difficult to criticise the judge in terms of how this ended up in a situation where no skeleton argument went in. There was no indication from the appellant at all it wished to make this argument. What looks to have happened is the appellant came in looking to make the two arguments which it then made and which were dealt with. Whenever my client said, but I have a point where I want to upset the judgment, and the court said, you can't, only then did the appellant say, oh, so that means we can't argue that. And it certainly looks on the transcript to be opportunistic.
Sorry, can you make that?
Absolutely, my lady.
Take us to the part that you're getting.
Of course. So far I've taken you through to the top of page 46.
Yes.
And my lady will have noted that so far there is no indication at all from the appellant that it wishes to make an argument that it should get its costs. In other words, that the court's preliminary view should be varied to that extent.
Indeed.
Quite the contrary, the extract from the transcript at the bottom of page 45, in which from H onwards, Mr. Williams says, I do not seek the cost consequences be varied in the totality of give us all of our costs, on the face of it points the opposite direction, that this was not a fallback position, but rather was the position which they intended to argue coming in. That, I say, if we go over the page to 46, is supported by what then happens from 46 and 47 onwards, where the appellant moves off the issue of the costs of the trial and moves on to various issues about previous cost orders and points of detail to do with that.
Yes.
And so that's what happens from 46 paragraph C onwards.
So that's the so-called simple issues.
Yes, the simple issues being
relate
about
to previous orders.
Exactly so. That's what happens. My learned friend, Mr. Williams, deals with the point we had made about cost offers. Then deals with the point saying, I don't want to vary the totality of the offer, but I do want £5,000 by reason of the failure to follow a pre-action protocol. Then moves off to what the simple issues are, which, as you'll see from 46, 47 and 48 are all about previous cost orders.
Yes.
Then at page 49, Mr. Carl is given a chance to deal with that. And Mr. Carl does so over the course of page 49. And at page 49, he says at the bottom, so I would suggest to Your Honour that there be no costs awarded to Mr. Limbani, because that is what the court already decided. And if Mr. Williams disagrees with that, he has a remedy at the Court of Appeal. And it seems we should move on to other issues. That, as you now can see, is consistent with at least part of the skeleton which he had put in, and which nobody had told him he was wrong about. Then the judge comes back, as my learned friend has already shown the court at the top of page 50, which says, I'm not going to revisit my judgment. And he says what he says there. And the judge deals with it along those lines. And that is the first time that the court has indicated ever, as far as I can see, I'm not going to deal with this. And as I accepted before lunch and I accept now, something has gone wrong there, given the terms of the previous judgment. Yeah. And the points I'm making is to explore, to show the court why they went wrong. It is only then, after those points have been made, that the appellant jumps on that, and if we look at 56E, comes back on it, and it's only at that point that the appellant, having opened the case saying I have but 2 small points, and having dealt with those 2 small points, 2 points, and then he dealt with some small ones. Having dealt with the 2 points, the first one being reliance on the offers, the second one being failure to follow the pre-action protocol. Having dealt with those 2 points, then hearing the judge say, I'm not going to go back in the order, it's only then we see at 56 the appellant making the point that he does.
I mean, still after the judge has raised by, but at 51H, he does say, I've not actually finished. I try and assist you a little bit because I have not finished my submissions, which necessarily are cost submissions, those being the only issues in play for Mr. Limbani. So it may be he did intend to run the point, and I think that's the gravamen of what Mr. Williams has told us this morning that he had to make.
Well, let me be clear. If that's what counsel is telling the court, I don't say that the court should say that's not true. Right? I don't say that. Counsel has told the court that. That's what the court, I think, should proceed on the
judge's perspective. He might well have reasonably drawn a different conclusion, which is a separate question.
Quite so. So where I'm left with is to say, okay, something has gone wrong. And frankly, it doesn't really matter whether Mr. Williams is correct or not in his recollection of this, but I invite the court to accept that he's correct. Ultimately, the court went wrong. The question is what we do about it. This is a procedural irregularity. The question is whether it's caused injustice. And that question, in my respectful submission, turns on the points which Mr. Williams now tells us, frankly, he would have made had he been allowed to do so. And he has had a full chance to articulate those today, including with the benefit of a leader as well. And again, I can be frankly about it. If the court takes the view that those points are good ones and should have persuaded any court listening to them to reverse the preliminary rule, then it's difficult for me to say there has not been an injustice. The court takes a different view and takes the view, having heard those submissions, that in fact there is no good reason why that should have reversed the preliminary review, then there has not been an injustice.
The way you frame the question is quite interesting. If there had been no preliminary review, judge exercises cost discretion, let's assume it's procedurally unfair, Court of Appeal so decides, then the Court of Appeal just does the job itself, doesn't it?
That's exactly why I used the words I did.
Yeah, and it doesn't start with the deference that appellate courts normally show towards first instance exercises of discretion, because by definition that is vitiated by the procedural unfairness. Now here we have the curiosity that the provisional view is given.
Yes.
And you say the question for us is whether the material should cause it to be reversed. Is that the question, or is the question what is the appropriate cost order in this case?
So I have a primary position and a fallback position. My primary position is, in the circumstances of this case, where the court who's heard the evidence has expressed a preliminary view, and then what has gone wrong is a failure by the court to allow submissions to displace that preliminary view. I say that at least some deference should be given to the preliminary view.
I knew we'd find an issue of general principle in this case.
You can always find one.
I'm glad to oblige. It's an interesting point, and I've looked for some case law on it, as you might expect, and there is no case law on this precise point. If there was, I would have shown it to the court. I don't think I need it, but let me step back and approach that. My fallback position, by the way, the court probably is quite aware of, which is if I'm wrong about that, and the court is just going to approach this anew, then the court should approach it anew, but should do so on the basis of two things. Firstly, the unappealed findings by the judge, and secondly, with the knowledge of the submissions that would have been made, because you've had those submissions this morning.
Yes, it seems to me the submissions that would have been made are relevant in both must be critical to both your primary and your fallback.
They absolutely are, because...
Put it another way, is there anything that calls into question the judge's preliminary view, or should have called into question the judge's preliminary view?
It depends what my lady means by that question. If you take the view that... my eventual answer is no, but we have to be quite careful about the question we're asking. What should have happened here, by way of procedure, is that the appellant should have had an ability to say whatever it wanted.
Yes.
To seek to persuade the court to depart from that preliminary view. So in that sense, there is, I guess, something that could have put it in question. But the real question for this court to grapple with, there are two questions. Firstly, is it right as a matter of general point that where a court has expressed a preliminary view subject to more argument, that preliminary view should be given weight and should not be disturbed unless the court thinks that the submissions that would have been made are sufficiently weighty to disturb it. So in other words, you don't start with a blank sheet of paper, you start with the conclusion in pencil, and the court has to work out whether or not to erase the pencil. I say that is the right starting point.
Well, one reason for... one of the difficulties here is that would precisely be the position, effectively, if the judge had heard those submissions at the consequential hearing. He had expressed a preliminary view, and therefore... and no one is suggesting he was wrong to put something in his original judgment,
I understand.
Expressing a preliminary view. So it seems to me inevitable that with that preliminary view in there and not, if you like, crossed out as a matter of actual fact, that the appellant needs to do something to shift, or would have needed to do something to shift the judge from that position.
Yes, particularly in a situation where that preliminary view doesn't arrive without explanation, but is the culmination of a series of findings,
yes,
which are then collected together in a preliminary view expressed at the end.
The difficulty that this court has is that clearly the trial judge, with the knowledge he has of the proceedings, is better placed than this court to deal with the submissions that we've heard this morning. Would have been better placed.
Yes, and that is a difficulty. But I say the difficulty is overcome in two ways. Firstly, as I say, the correct approach is for the court to say, we are going to give deference to the preliminary review, and we require the appellant to convince us that the submissions it would have made should have been sufficient, not would, should have been sufficient to move the court from that preliminary review. So that's giving deference to the preliminary review, but no deference to how the court would have approached the submissions that followed.
Just exploring that, the reason the judge gave a preliminary view is because he rightly recognised that there had yet to be an opportunity to make submissions on the points, otherwise he would have given a final view.
Yes.
And this approach gives some sort of privileged status in the sense of requiring rebuttal of statements which were not binding statements precisely because they have not been subject to due process arguments. So there is...
I see my Lord's point, but it does, and I don't like the word privileged status. The way I put it is that the court's preliminary view should be given weight, but it is weight that could be overcome if this court takes the view that the subsequent submissions should have moved the court from that view. Not would. I'm not saying that the court needs to be satisfied that this judge would have been moved from the view by those submissions. I'm saying that this court has to be satisfied that this court, that the judge should have been moved had those submissions been made. And that involves giving weight, but not privilege to, the initial preliminary view.
I wonder if there is as much difficulty on the facts of this case as there might theoretically be, because it seems to me there's two categories of thing. One in the so-called preliminary view that is expressed, there's expressions of views as to the facts of the case.
Well, there's more than that. There's findings, my lady.
And findings that the judge has made.
Yeah.
It seems to me the appellant has got a much... Legally, the appellant can say that finding isn't relevant or shouldn't be relevant, but it's much harder to say that is a factual finding that is wrong.
Well, they can't say that.
Well, they can't, really.
They can't say that. we have the appellant's notice.
It politely,
they can't say that. So, and that's why my skeleton...
But it's totally open to them to say, well, yes, there were these findings that Mr. Rimbani didn't cooperate, but that's nothing to the point. And you can also answer that.
Yes. So let me be clear. Theoretically, I am not actually convinced it is open to them to simply run a freestanding, none of these things are relevant, because that's not the appeal that has been made.
Yes.
That's not the grounds, and not even in the argument. But it's not my first time appearing in this court, and I recognise the court's going to want to read the right answer no matter what precise the grounds of appeal are, so I'll deal with it in terms. Even if I'm wrong that there should be any way, and I'm dealing with my lady's point, but I'm having a run up to it. Even if I'm wrong that there should be weight given to the preliminary review and this court just has to approach it anew, so this is my fallback position, I say the following. Number one, if the appellant's case does now include an attack on those factual findings as to what happened, then it's hopeless. Let's assume for a minute that this court says, fine, it's not in the grounds and it's not really in the skeleton, we'll entertain it. And that's fine, I'm happy for the court to do so. Let me be clear, the court should get the right answer. What's the basis for overturning these factual findings? They are detailed factual findings that turn on a history of the matter that the court looked at and a consideration of both the witness statement and the factual evidence before him. There is nothing has been put forward before this court to satisfy this court that there is any basis at all for overturning those factual findings. And such as there has been, I can deal with quickly. the suggestion that the court was wrong to say that there'd been a failure to disclose. Well, sorry, before we get there, the factual findings as to Mr. Lambani's factual participation in the fraud that happened, I don't even understand there to be an argument made today that those factual findings should be impeached. And if there is such an argument, there is no material before the court, either an argument or factual material, which would justify such impeachment. The next layer of finding is, what does that mean about Mr. Lambani's conduct in the case? And the judge has given a reasoned judgment pointing out what emerged during cross-examination. Firstly, what emerged from the documentary record and all the other evidence in the case and cross-examination, which led the judge in the passages I brought you to conclude that Mr. Lambani both failed to disclose documents and failed to disclose relevant factual matters and gave false evidence. And again, there is nothing has been put before you in either the appeal bundles or in oral submissions, which in my respectful submission could possibly justify impeaching those conclusions as well. And dealing with that in turn, the suggestion that the judge is wrong because there was no specific disclosure application, I don't even understand that argument. What is that argument? They had an obligation to disclose things and an obligation to come clean to the court and to give truthful evidence. The suggestion that they cannot be criticised for disclosing things because there was no specific disclosure application, in my respectful submission, is incoherent. The suggestion that they cannot be criticised for failing to disclose their participation in the fraud by giving a witness statement that didn't include those factors is incoherent. The court expects parties who come and give evidence to it to tell the truth, the whole truth, and nothing but the truth. Not to fail to disclose matters entirely relevant. And certainly the suggestion we heard this morning that these are matters which do not go to anything relevant in the case. And I'll come to look at the law about cost in a second. I keep promising / threatening that, but I promise I will. But the court knows that's just not a realistic argument. It would be different, and it's entirely possible to have a claim where somebody tells a lie about part of the claim and it has no relevance to other bits of the claim. Of course that's entirely possible, and the case from last Friday, as my lady knows, was a paragon example of that. But that's not this case. This is a case where the findings of the court are that Mr. Lambani failed to disclose / hid and gave false evidence about his participation in the fraud. And hid and gave false evidence about the communications he had had with others involved in the fraud. And that, I respectfully submit, goes to the heart of the case. So against that background, can I bring you to the law? The starting point is obviously going to be what the CPR says about costs. Let me just bring it to. So, in the authorities bundle, let me start with that. In the authorities bundle, you should have at page 153
Yes.
of that bundle, which I think is tab 9.
Yes.
So there, at page 153, you have CPR 44.2, headed Court's discretion as to costs. This I know will be familiar to the court, and I will not labour it. But as the court knows, 4.2 brackets 2 brackets A makes it clear that the general rule is that the unsuccessful party will be ordered to pay the cost of the successful party. But B, the court may make a different order. And then in terms of the different order, we have subsection 4. In deciding what order, if any, to make about costs, the court will have regard to all the circumstances, including A, the conduct of all the parties.
Yep.
I did not understand the submission made earlier today that the conduct and the findings which the court has found is conduct which, under the rules, the court cannot take into account when assessing costs. That is simply wrong.
Yes, we did hear a submission to the effect that if the appellant's conduct did not do something like lengthen the trial, then it shouldn't be relevant.
You did, and it's wrong.
Yeah, you've answered.
I will show you the cases, but I can cut to the chase. The real question, whether this court approaches it anew or it's asking the question, giving deference to is whether making a no-cost order, I'm going to call it no-cost order, which I mean the other side don't get their costs, is a proportionate sanction for the conduct. That's the test. And I flag up that's the test because, again, as I understood the submissions being made this morning, they were to the effect that conduct can only be relevant to costs if it is conduct that increases the cost of a trial or in some way, to which the answer is, well, that's not what the case law says. The case law says that conduct can be relevant to costs both because it does increase some element of the process, including the trial, or as a sanction for the conduct of the parties. I mean, I can take you through all the cases that say that, but it may be sensible to start with, I'm going to call it my lady's case. I know my lady was one of 3 on the panel, but my lady's case of last week. It's not really clear whether the other side rely on the case. This is a case we put forward this morning, hadn't become maybe last night. I became aware of it last night. But we can, if we work through it relatively quickly, it is a useful and could not be more recent pulling together of the judicial thinking on this. First page, paragraph 1. The court pulls together and sets out the some authorities in relation to this. Throughout the rest of the case, the court considers and looks at the CPR from paragraph 40 onwards. At paragraph 42, the court records, it is common ground that in exercising the power to make an order for costs under Rule 44.2, the trial judge has a wide discretion and is better placed than an appeal court to make an order which best fits the justice of the case. The respondents say the judge's decision to make no order for costs in relation to a partnership claim, the Part 20 claims within the permissible limits of the discretion. The appellants, on the other hand, say the exercise of discretion was flawed because she did not take into account the extent of Mr. Donnellan's dishonesty, and she only paid lip service to the principle that costs follow the event. There is then a passage which, in my respectful submission, is the opposite passage to look at from this judgment, because it deals where there is dishonesty for one party and not both parties. As my lady will remember, there's a whole stretch of the decision which talks about, well, what does a court do if both parties have been dishonest? And that's one of the reasons I brought you to that passage in the judgment in our case.
Yes.
And you can see that 44, it is important for judges asked to take dishonesty into account when making a cost order at the end of the trial to consider what is likely to occur in assessment. Then at 45, the court's powers in relation to the putting forward of a dishonest case include A, disallowance of that party's costs in advancing that case, B, an order that he pay the other party's costs attributable to proving that dishonesty, and C, the imposition of an additional penalty, which, while it must be proportionate to the gravity of the misconduct, may in an appropriate case extend to disallowance of the whole of the successful party's costs, or in order he pay all or part of the unsuccessful party's costs, and then as a reference to the Bank of Tokyo Mitsubishi. And then at 46, where the court is asked to make some out of the ordinary cost order in consequence of the alleged misconduct of the party against whom the application is made, the court must bear constantly in mind the conduct of the party making the application, and that again is a reference to the Bank of Tokyo case. Hutchison and Neal is then relied against. And over the page there's an extract from Hutchison and Neal. And just looking at the end of that extract, as Mr. Justice Briggs observed at paragraph 19 of his judgment in Bank of Tokyo, the full range of measures is available to ensure that the dishonest but successful party does not gain and the honest but unsuccessful party does not lose in consequence of the wrongdoing established. Then at 48, I note at this point that the objective is not merely that the dishonest but successful party does not gain from his dishonesty, but also that the honest but unsuccessful party does not lose. This is not addressing a situation where the unsuccessful party is also dishonest. And that, my lady, my lords, is what I say are the key bits to take from this judgment. As I say, over the page, from paragraph 51 onwards, there is a detailed exposition of the law in relation to dishonesty on both sides, which isn't relevant here. There is then, as my lady is only too well aware, a detailed consideration of the findings which the court made below in that case, and the extent to which, and I'm paraphrasing but I hope fairly, the extent to which the dishonest conduct established infected one of the claim or more of the claims. And the court concluded, and again I hope I paraphrase fairly, that the dishonesty established affected one but not more of the claims, and even within that claim it was wrong for the court not to take into account that the dishonest party also had to incur costs in showing the dishonesty of the other party. So I started with that case because it occurred to me that it is probably the most recent. But I say it fairly summarizes the other cases which led up to it. And if I can just very briefly show my lords and my lady the cases which it ended up summarizing. So if one looks in the combined authorities bundle, not all the cases are going to be directly relevant to this. There's quite a lot of cases, as the court knows, on the deference the court should show to the orders below, which I think this court probably has a good grasp of, and I'm not going to take it to the authorities. But if you look, for instance, at the Widlake against BAA case, which is paragraph 28, sorry, I said paragraph, I meant page 28. So it starts at page 28. The relevant extracts you will find lined by me at page 35. And in particular, paragraphs 20 and 21. I don't want to read it out to the court unless the court would like me to read it.
I don't think we need it read.
You know, at least because my voice is going, as you can probably hear. Then at page 43, paragraph 33.
Yeah.
So that, I hope, is in accordance with what of the exposition of the law which I took from the first case. Abbott v. Long, and I'm not going to show you all the cases because it's pointless, but I'll show you one more. Abbott v. Long, 2011, EWCA, Civ 874, page 49, sets out Rule 44.3. Page 50, held dismissing the appeal. The burden was on the claimant to show that the judge, in making no order as to cause it, erred in principle or was perverse. Then, looking at the conduct, it said in the head, it was still blameworthy conduct in relation to conduct of the litigation, and that the judge was entitled to take into account the conduct which he carefully described and which he'd marked a clear disapproval, and there was no basis for saying the order was a disproportionate sanction which the judge was not entitled to impose. And that is taken from page 53, paragraph 10. And then, pretty crucially, paragraph 16, page 55. That leads to the next point. As I see it, therefore, the criticisms made by the judge of the conduct of the claimant were well outside that of a misjudgment. It amounted to a finding of blameworthy conduct in relation to the conduct of the litigation. To that, Mr. Williams submits that the judge has to be satisfied that it is proportionate to deprive a party of costs which it cannot be said were caused by its conduct. In this case, I've already explained the judge was entitled to make the reduction in costs in relation to the failure and the duty to mitigate, but on the question of deprival and costs on the grounds of misconduct, there was undoubtedly jurisdiction. See, for example, Woodlake versus BAA and Walsh against Singh. And then there's an extract from Walsh against Singh set out, and the learned judge concludes, in this passage I make it clear that if the court is going to deprive a party of costs on the grounds of misconduct, which has not been causative of a waste of costs, it should be satisfied the sanction is a proportionate sanction. And that's what my submission is that represents the law. So the question for this court then, if I turn to the third segment of my submissions, the question really boils down to whether, given the findings of the learned judge below, it can be said that he was correct or incorrect in taking the view that depriving this particular appellant of his costs was proportionate.
In terms of why the judge might have made this cost order,
yes,
he might have taken the view that a telephone call by Mr. Limbani or statement by Mr. Limbani to the police, later distributed to Mr. Carl in the form of a police witness statement and by email at the time, in which he had professed to be involved in moving a number of cars that Mr. Carl claimed an interest in,
yes,
would be an engine of litigation. It's fair to say that it's after the order and the raid and so forth that Mr. Limbani is brought in. He might have said a sanction, or he might have said some combination of both of them.
Quite so, and I put it too narrowly, because that's a point you made to my learned friend earlier, and I meant to pick up on that and run with it in the way that one should when one sees a good point. You're absolutely right. A couple of points here. Firstly, the nature of the findings are such that they are the engine room of the litigation, because what had happened, my lord has picked up, is that cars were taken from the claimant and they were disposed of, and the appellant's role in that, although the court has found does not amount to a conspiracy, was central. Because the phone call is such that places him at the centre of it, and the storage charges emails, which the court has, invoices and payments, not just emails, are central. And so the suggestion that this did not drive the litigation is just one that cannot be made out. And the court will have noted from the submissions made this morning that the appellant just does not grapple with this. It ignores the central aspect of this. It characterises all the findings as being on issues which are not relevant to anything. And that's one of the reasons why I took the trouble to actually go through the judgment with you in the 15 or 20 minutes this morning, to show that just is not a submission that can be made. And so you're absolutely right, my lord, that the learned judge's decision appears to have turned on taking the view that there's a series of findings which I, the judge, am making, which place the appellant at the heart of this fraud, albeit on the law, I'm not satisfied that conspiracy is made out or conversion. And I have reached the view that he has adopted a deliberate course of conduct to stop what in fact was his role being discovered. That's what the judge is saying. And so for both of those reasons, it looks like the judge was saying, but you, the appellant, are in the thick of this, and I don't think it's appropriate you get your costs. And it looks like the judge is saying, I wish to register my dissatisfaction with the course of conduct you have adopted to avoid proper examination of your role. And for both those reasons, I say this court can be satisfied that it's a proper use of discretion to say that this appellant does not get his costs. Whether or not you afford any weight to the preliminary review, if you're approaching it anew, the point I'm making is you approach it anew from the perspective of the findings of fact which this court has made about the participation of this particular appellant in the events, and the findings of fact which the court has made about the appellant's course of conduct in seeking to evade proper examination of that. Either of which would be sufficient. But both of them together, in my respective submission, are clearly sufficient to justify the order. And I've tried to do this in a non-jury way, but indulge me in this slightly jury question. In what case would it not be appropriate to defy the defendant of their costs if it's not a case where a court has made express findings of the defendant's participation in the fraud and that the defendant has adopted a course of conduct to disguise that? I use fraud for conversion, conspiracy. Second jury question, can it possibly be right that the defendant that the appellant, having spent money in such an enterprise, i.e. a false witness statement, a failure to disclose, an attempt to hide all that, should then have those costs paid by the innocent Jew? Because that's what the appellant's after. It is after a cost order that means that my client would pay the costs involved in the course of conduct adopted by the defendant. Let me deal with the 4 or 5 points which Mr. Williams said he would make and deal with them head on. His first point was disclosure, and I hope I've already dealt with that.
Yes.
The second point I noted as evasiveness, and the suggestion that he'd not been evasive. It's difficult to understand how it is not a proper description of the conduct which the court has found in giving false evidence. It's difficult to understand how that cannot and should not be described as evasiveness. What is evasiveness if not giving false evidence?
I think we've got your point about the judge's factual findings, and you've taken us.
The third point which I think was made was that there hasn't been any failure to disobey court orders. But if there has been a failure to disclose relevant documents, and if there has been filing of false evidence, that can't be right either. It's
one of the more mysterious parts of, because there was a prior court order in this case. It's the order that culminated in the raid. And yes. I think it's unclear to me whether the judge had in mind the post-raid conduct of Mr. Limbani, but the judgment is just not clear on that.
It's not clear. It is just not clear. My whole reason for going through the judgment with precision was to make the points I can make and avoid making points I can't. We only can go on what the judge has said, and my submission must be that what the judge said is good enough. As you've seen from my submissions, I say it was more than good enough. But it must be. I'm not quite sure what the fourth point was, but I know the fifth point was that the court was worried.
The fourth point was the Part 35 medical position.
Well, I didn't note that down properly. I think I dealt with that earlier. There is nothing in the judge's decision to suggest that the judge was in any way prejudiced about the medical evidence, disbelieved the medical evidence. There's nothing to suggest that the judge in any way took the medical evidence into account in damning the appellant. It's quite the opposite. The judge looked really carefully at this.
Lord Leggett has long been telling us we must rely on inherent probabilities in contemporaneous documents and not demeanour.
In a lot of ways, the judge is to be commended, right? He was facing, and I was discussing this with my solicitor. He was facing a trial where there was one counsel there who was representing two parties, but as far as I can see, from the closing at least, the judge was largely left to his own devices to make what he could of this, and to end up in a situation where the judge produced the judgment he did. This court doesn't need me to say it was commendable or not, but I submit it was commendable, the judgment that was arrived at, on the basis of virtually no help. And particularly the ability, much against my client's interest, but there we are, to disbelieve a witness, think a witness was involved in not telling the truth, but to still apply the burden of proof in the way the court did is commendable. And as I say, the suggestion that he did not like the appellant is unworthy of what in fact has happened in this case. That's not what happened here. So that's the medical evidence. And the fifth point that we are told is the point that would have been made on costs, is the suggestion that the appellant did not engage with the litigation. I have to say I had not read that as one of the reasons why the judge had awarded the no order. It was obviously an observation which the judge made about the conduct towards the start of it. But my lords and lady, you will have read the judgment. It doesn't strike me that any part of this cost judgment was about non-engagement. It's the opposite. The cost order is about engaging but telling mistruths.
We've had material in writing, but less so orally, to do with the use of the D.C. Robson witness statement and hearsay and so forth. At the moment, I'm unclear as to whether that's an issue at all on the...
If it is, it is entirely incoherent. As I understand the argument is it's hearsay evidence and should therefore not have been considered, which the answer is civil litigation. It is admissible evidence. The judge didn't
rely on it as evidence of the truth of its contents because he found what had been said was untrue. But had been said, and he then had to ask why.
That's a good point. As I read the judgment, the defence proffered to this was not... What was not said was, that's not a true document.
Yeah.
What was not said was, that is a true document, the police officer made a mistake in the note-taking.
Yeah. And
what's not said is that the police officer didn't make a mistake, she deliberately misrecorded anything. What is said is, it is on the face of it a true document that accurately records what's said, but a big boy stole my phone. The judge was entitled to work out on the balance of probabilities whether a big boy came along and stole my phone was likely to be true or not, and the judge took the view it was unlikely to be true. If there's any element of this where the judge is entitled to look at a witness and hears how the big boy stole my phone defence was proffered, that must be firmly within the ambit of a trial judge. So whenever I took on the case, I've never understood what the hearsay point is. It's admissible evidence. The evidence itself doesn't appear to be disputed. what is an issue is what's the explanation for that evidence.
Yeah. I mean, I don't know whether D.C. Robson would have 10 years on have realistically been able to add it anyway.
We've done enough work.
Yeah.
The police officer would turn up, produce her statement and say, at the time I put in this statement, it accorded with my understanding at the time, and I now have no independent recollection. If she said anything beyond that, I think we'd all in the court be rather surprised. But it doesn't matter, because as I say, as I understand the case as was run, it's not whether by accident or design, that's not what happened, what's set out in the statement. It is, big boy came along and took my phone. And that's slightly facetious language, but the court has the point. There's a last point to make about how the appeal is put together. And again, it depends on how strict this court wants to be about saving grounds of appeal.
Yes, I did wonder if you were going to go back to the ground.
Well, it does depend. Some members of this court are stricter than others about the grounds.
Well, I think you should make the points you want to make.
Right, let me do that. Okay, so the grounds are at 14 and 15. And I don't want this to send to a jury thing, but looking at ground 1, it says the reasons which are given for the learned judge being wrong to disallow the appellant's costs are as follows. Reason 1, the learned judge took into account purported non-disclosure, which was not a material consideration before him. So point 1, it isn't purported non-disclosure. It is found as a fact non-disclosure. So right there, some members of this court would run a red line through that ground.
Well, it does suggest that there was no evidence or submissions on this point, which would be a form of challenge to that finding, wouldn't it?
Fine, so I'll get to that. The learned judge took into account purported non-disclosure. That doesn't work, which was not a material consideration before him. That doesn't work. We just looked at CPR 44. Of course it's a material consideration. And was not an issue before him, and no evidence or submissions made on it. Well, we know it was an issue before him, and we know there was evidence on it, because the learned judge records in his judgment the cross-examination by Mr. Carl about this. And we know there was evidence on it because the learned judge records the evidence there was on this, and then says he disbelieves it. So far, in 4 lines of a ground, it is materially inaccurate in 4 ways. The point which is left, as the learned court indicates, is the point about whether or not there were submissions on it, and then the preliminary review only, without hearing submissions. So that's the point that's got some legs, as I've conceded. Then ground 2. Ground 2 is materially wrong. When it says the learned judge would not hear or allow any with any underlined submissions on costs, we know that that's wrong. The learned judge did hear submissions on costs, and not just the costs of past proceedings, but also the costs of the main action. So the reason I haven't concentrated on this is some courts would take the view, look, those grounds just aren't right, and those are the grounds you've drafted, you're stuck with them. I recognise this court is likely to go, well, I can pick the bits out of those grounds that I need to decide.
Well, I think you've said as much. You can take bits from ground 1 and ground 2.
Yeah. And the oddity is this is filed on the 13th of February 2025, before the judge has handed down the consequentials judgment.
I'd not even picked that up.
Page 10. And then by the time the matter comes before Lord Justice Newey, who gives permission to appeal, I think the replacement skeleton at 16 is before the court, and I think that is must have been what was before the Lord Justice when given permission. And it's fair to say that casts the net a little wider.
Well, there is some authority, of course, as to whether a skeleton argument can expand the grounds of appeal. I think this court can see where I'm coming from in this.
You've come prepared to deal with what's in
I have come prepared to deal with whatever's thrown. I think this court would prefer, particularly in this rather long-running saga, would probably prefer to deal with the actual points of argument that are being run rather than take procedural points. And that's what I've tried to do today. My lady, my lords, that has ranged far and wide. I've tried to deal with everything I can. Is there anything else I can help you with?
Thank you.
Thank you very much.
Mr. Lee.
Lady, can I just turn my back on you? I need to go and take some instructions on something from behind me. Then I can carry on. Thank you. Thank you, my lady. The easiest way is to start at the beginning and go through the points to bring this together rather than simply trying to put this cogently into some kind of organised response. I want to pick up things my learned friend dealt with and correct them and deal with some law as I said I would. I was criticised. My learned friend began at 10 to 1. If your my lady and my lords are time stamping their note, but around 10 to 1, when my learned friend got to his feet, he made the point, picking up something I'd said at the beginning, that really what the claimant had been doing was threatening, or interiorum was the Latin phrase I used, and I was criticised for phrasing it that way, as being categorising what the claim was all about. In other words, my learned friend was trying to displace that his client would be doing anything other than bringing a proper claim which he lost. But nonetheless, it was a claim properly bought. And the first point is, at page 205 of the core bundle containing the judgment, we see exactly how his lordship down below categorised this in paragraph 23. I took you to it at the beginning. Therefore, it's incorrect to suggest that in some way I have exaggerated or used some inappropriate, colourful language. Paragraph 23. Mr. Carl's objective, as noted by the trial judge, was not to obtain damages from Mr. Limbani. We're just pausing there. If one brought a claim in court on the basis of conversion or conspiracy and said, I'm not about damages, one might get short shrift. But, the judge says, to persuade him, that's Mr. Limbani, to give evidence as to what he knew of the dealings involving his cars. Well, whatever came of that plan, it's quite obvious the judge saw through what Mr. Carl was actually doing. I'm perfectly entitled to and should, and my learned friend's criticism should be ignored, that Mr. Carl, despite all the things the judge said about him, was a litigant in person who did a great job bringing a claim properly brought. Because it's plain from paragraph 23 that the judge saw what he was doing. And that should colour any consideration of costs. I accept that my learned friend effectively has made a volte-face from the position we found approaching today, namely, you've got the wrong point, you were heard, and anyway the judge had discretion, go away, bluntly summarising the response to, well, I recognise the court might be considering whether overall we should be exercising discretion given the fact that you were deprived of the opportunity to make representations. But if we are looking at principles of how does one exercise CPR 44, which on the face of it gives a wide discretion, I'm going to come back to the point I made about behaviour and what relevant behaviour is. The starting point must be that the judge himself made a finding, which is not appealed against, that, leaving aside that no one could possibly perhaps even appeal these, but putting that aside, the point is we're criticised for not taking points. I can make the same point. Mr. Carl's case against Mr. Limbami was characterised by the judge in the way that he did it. So far as what behaviour, and I sense from Milady that, if I may say, Milady perhaps, either I expressed myself insufficiently or Milady drew the wrong inference or understanding from what I was saying. What I said was about behaviour, there are two types of behaviour a judge could take into account. From the authorities, as a matter of experience, there are all the relevant cost matters. Did you lengthen the trial? Did you delay things? Did you bring the proceedings on yourself? Did we spend time chasing rabbits that we didn't need to chase, etc.? But I also, the court will recall, said there are times when a court decides someone's behaviour is so egregious, I use that word because it's a word in the judgments, is the behaviour so egregious that the court should somehow reflect its moral discomfort with what a party's done, to the extent that the ordinary position under CPR 44 should be displaced.
Okay, and did you say you come to the authorities on that? Because I think you're saying that only the most egregious conduct should justify that.
Because, Milady, although, and in some ways, if one looks through the authorities, and I hope I can take this shortly rather than going through it, but if we went through all these authorities...
Well, we don't need to go through all the authorities, but if you're maintaining that only what you describe as really egregious or egregious conduct is sufficient, then I think you need... I mean, for example, I can see one reference to egregious in Woodlake. Is that sort of thing you've got in mind?
Yes, page 46 of the bundle, paragraph 41 of the Woodlake case. It's a passage my learned friend also relies upon.
That's saying in addition to looking... Well, we need to read this in context.
First, he deals with exaggeration. So, again, exaggeration led to time spent that wouldn't otherwise have to be spent. Someone gilding the lily in their case. In addition to looking at it in terms of cost consequences, again, framed as cost consequences. So, it's implicit from the language that there has to be a cost consequence. He's not talking about generally CPR 44, he means a cost consequence. The cost consequence of you doing something in a case will be, you've lengthened it, you brought the proceedings on yourself. We spent time dealing with something that wasn't properly an issue, should never have been an issue, etc., etc. The court is entitled in an appropriate case to say the misconduct is so egregious that a penalty should be imposed on the offending party. But it goes back to my point, my lady, that one still has to do something which in some way has either brought the litigation on oneself or in some way made the costs incurred by the party that doesn't get them, such that the court's going to say, I'm not going to give you your costs. It's effectively your fault. And I put it that way because if one looks across the page, for example, one sees there, page 47, middle of paragraph 44. This is what happens when you, can I put it this way, misbehave rather than keep saying egregious, etc. Pursuing her claim in an exaggerated way in the middle of paragraph 44, she did, this is the claimant, she did have the result that this became heavily contested litigation, whereas it might have settled. Again, one can see the thrust of what's behind the court's dicta, that what we're looking for, what one should be looking for, is something that has caused unnecessary litigation, whether it was simply starting it or having started it, it not getting to the end. And I go back to the point on page 23, milady, in the Painting and University of Oxford case.
Sorry, page?
Page 23, another authority relied on by my learned friend. Going backwards through this, but I'll deal with this and I've got one more point in this. On page 23, at the top of page 400 of the case, he concluded that this was the this is that court looking at the Islam and Ali case of 2003, another Court of Appeal case. And what the judge took was, he concluded that on an investigation of their issues and their resolution, the reality of the case was that Mrs. Ali was the winner and Mr. Islam had lost the case on principle in relation to the main issues. Again, it really does go back to the general thrust under 44. The winner, whoever that is, either the party bringing the claimant succeeding or the party defending the claimant succeeding, they should get their costs. And it is frankly a high hurdle or a heavy burden, however one wants to phrase it. And I would invite the court to consider this. If we're right and the court has some sympathy with our argument, but leaving aside, well, if the court has some sympathy with our argument, what we have here is someone who was deprived of the opportunity to make points, good or bad, and now stands in the Court of Appeal, who clearly were not there at the trial, who were not as familiar with what the trial judge was familiar with, and counsel 18 months later or something is being asked, what might you have said to the judge? And one's bound to say, it is unfair, but this court of course has, as my learned friend recognises, got to deal with that unfairness. But we are the losers. It's not about Mr. Carl not winning his case. He lost bits, won others. It's about Mr. Limbani successfully defending himself against a claim that should never have been brought against him, characterised as a form of coercion by the judge to give evidence against others, and then not getting any of those costs other than whatever other prior other orders have been made which remain outstanding and unpaid. That's the point. And therefore, in terms of principle standing here, Mr. Limbani is entitled to say, well, I effectively won. Why should that be displaced? What can we go on? And, of course, paragraph 21 of the Johnsey Estates case and Secretary of State for Environment on page 10, another one of my learned friend's cases. Again, a passage he relies on. But if we look at paragraph 21 on page 10, the principles applicable in the present case may, I think, be summarised as follows. Costs can't be recovered except under an order of the court. Question whether to make any orders to costs, and if so, what order, is a matter entrusted to the discretion of the trial judge. The starting point for the exercise discretion is that costs should follow the event. What was the event? We won. Nevertheless, the judge may make different orders for costs in relation to discrete issues, not relevant here, and in particular should consider doing so where a party has been successful on one issue but unsuccessful on another issue, not relevant here, and in any event may make an order for costs against a party who's been generally successful in the litigation. and the judge may deprive a party of costs on an issue on which he has been successful if satisfied the parties acted unreasonably in relation to that issue. I emphasise those words because, again, everything is tied back to what is it that you've done, in this case, what are the findings the judge made, and what connection does that have with an issue in the case? As I said earlier, it's not simply a matter of one's ipsy-dixit. It's not a whimsical decision as to how one makes cost orders simply because one may not approve of.
No, we have your submissions on that.
An appellate court should not interfere with the exercise of discretion, but well, obviously we know it wasn't properly exercised in this case. Now, I may continue. Again, and I apologise if I'm jumping around, but I'm bringing this together in hopefully a coherent manner for the court. Page 55, the Abbott and Long case. Again, just below at the end of a passage, sidelined by my learned friend. Just to pause, if you go back to paragraph 15 before that, you'll see there one of the words used by the court. I'm hopefully taking this as a sensible gallow. In the middle, it's still, the word is blameworthy conduct. Again, it's language of blameworthy conduct. But going back to the end of paragraph 16, just before it gets to 17, he's quoted from the Walsh and Singh case. And then the judge says, in that passage, I make it clear that if the court is going to deprive a party of costs on the grounds of misconduct, which is what the learned friend would be urging upon you here, which has not been causative of a waste of costs, it should be satisfied that the sanction is a proportionate sanction. Now, that's important because towards the end of my learned friend's submissions, he referred to the Abbott and Long case. He took you to paragraphs 10 and 16. And the point was, that wasn't dealt with, this discretion of a court, of a judge under CPR 44, has to be exercised in a proportionate manner. Proportionality, one understands general principles overarching the whole of a litigation. We're familiar with CPR and the general overarching principles, etc. I don't need to rehearse those in front of this court. But actually, what one does have to remind oneself is, Mr. Limbani, one, Mr. Limbani didn't cause Mr. Carl any identified additional costs. Mr. Limbani didn't bring the action on himself. And there is nothing identified by my learned friend in all the passages that he takes you to about his client, what the judge thought about him as a litigant in person, and what he thought about Mr. Limbani, which went to the cause, went to the cause of action, or the causes of action. At some point, my learned friend used this phrase, was it proportionate, he argued, and then said, but the nature of the complaints are the engine of the claim. That was his phrase. I noted that. Nearly the end of his submissions, just before he turned to dealing with Mr. Williams' points. He said the nature of the complaints is the engine of the claim. Well, with respect, that's wrong. Two reasons. One, because if one looks at, I'm not going to rehearse them again, but if one looks at all the things the judge found against Mr. Limbani in the sense of, I say adverse findings, sort of unpleasant findings, none of it went to the cause of action that Mr. Carl had to bring. Because frankly, if they were relevant to some part of, or as my learned friend put it, the engine of the claim, the judge would have been perfectly entitled to say, you have hidden things from this court, I don't believe you, and I'm entitled to draw the inference that Mr. Carl wants me to, that joins the dots, that you were part of some conspiracy. It goes, for example, to the point about the police officer. I leave aside whether it was a draft statement, whether it was a hearsay, but the point is, the conversation that the judge accepts that the police officer has about Mr. Limbani moving cars, the one that Mr. Limbani doesn't remember, It could have been open to the judge to say, and as a result of that, I think Mr. Limbani was embedded with the others.
Yeah, we're clear about your...
Good. Well, it's very relevant, Mark, because what, m'lady, sorry, because in this jurisdiction, we don't have the Scottish criminal verdict of not proven. In civil litigation...
We're very clear, Mr. Lee, that this is a case where your client succeeded in defending the claim. That is the starting point.
And for completeness, this isn't a new way of casting. Paragraphs 11 and 10 in my skeleton, I would rely on.
Yes.
Now, going back, see what's left there for.
Can I just ask you this?
Yes, my lord.
If you look at the claims brought against your client.
Shall I look at the pleading in the
yes.
core bundle? Can I just turn that up, please?
Core bundle, page 261.
Page...
At least the conversion claim. And there are the 2 points the judge...
261. I've got a black and white copy underlined.
No,
yes.
well, likewise...
I think it was all coloured, but anyway, yes, the conversion against the ninth.
We've got the 959, which the judge deals with in the judgment, where he makes a finding that Mr. Limbani did take steps to assist in the sale of that car, but didn't have sufficient possession of it. Now, plainly, on the judge's finding, Mr. Limbani has involved himself in the sale of a vehicle at one stage advertised on a website for sale by his brother, it is alleged at least. And then we've got at 13U, the argument being made, if what Mr. Limbani told the detective constable is true, namely he moved those vehicles, including the famous F40, then he would have converted them. But the judge found that that was a dishonest statement made by Mr. Limbani to the police. The F40 was never imported into this jurisdiction, although in fact Mr. Carl was given a completely contrary account. Now, if on the judge's findings Mr. Limbani lies about moving cars and is then sued for conversion for his involvement in moving them, how can it be said that he has not brought that claim on himself by reprehensible conduct?
Can I just take one?
Yeah.
Because one has to remind oneself of the chronology. The claim had started not against Mr. Limbani, but others. Mm-hmm. This is an amended pleading, as you'll appreciate. What Mr. Carl did, having discovered that the 2 of the protagonists, or main protagonists, had used his services to drive them around, he considered that 2 + 2 makes 10. In other words, Mr. Limbani was in on whatever they were up to that was wrong. And so Mr. Limbani did not bring it on himself. He's someone who was identified as moving a car around on the eventually accepted evidence. But that does not in any way justify at all the suggestion that, okay, there was some evidence that you moved it around. That does not in any way justify a decision, and I'm not going to give you any of your costs simply because you hid the fact, as the judge must inferentially have determined, the fact that you moved the cars. Because we know, as the judge recorded, and as Mr. Carl says in his emails, I'm bringing you into this because really I want you to give evidence against them chaps because I think you were helping them shift stock around. And the judge decided, Mr. Limbani, as he could have said otherwise, of course, said, Mr. Limbani, no, you weren't part of that wrongful mechanism of shifting cars around. So, with respect, my lord, he doesn't bring it on himself. He's just someone in the wrong place at the wrong time, and for his own reasons decides, rather than, as it were, confess and avoid, he won't make any confession.
At Mr. Edwards' instigation, as the judge finds, Mr. Edwards having taken money off Mr. Carl for the F40 when no such vehicle ever enters this country, even though it's purportedly purchased, your client makes a statement to the police alleging he participated in the physical movement of such a vehicle, there providing Mr. Edwards with cover that there was indeed an F40 acquired, and is then sued on the basis that he did what he claims he did. The claim fails because the judge finds there was never such a vehicle. You can't convert a non-existent car. At the moment, at least, I'm struggling with the suggestion that he's not the author of his own misfortune in that respect.
Well, my lord, let's turn that around. Even if he has brought suspicion on himself, that in and of itself is neither a crime in this country nor is it a civil wrong. If someone acts on a suspicion and joins dots beyond what their value actually is, my 2 + 2 = 10 example, and you take proceedings against someone, that's the difference. Mr. Carl brought proceedings against him. He didn't have to. He could have left it where it was. He could have tried to call him as a witness, could have tried to get a witness order from the court, but he didn't. He actually put him at the centre of this maelstrom of dishonest conduct by these car dealers or whoever they were. Mr. Carl, having chosen to sue a man on the basis of a claim he did not succeed in, it would be unfair, and certainly unfair without any representations on the point, and I appreciate we've got to make them here, but it would be unfair to say, well, I know you won. You won hands down. But I'm not going to give you any money for it. He should never have been sued. As I said at the beginning, the court, including the Court of Appeal, is not generally a court of morals. Whatever we may think and whatever a bench may think, whether it's here or below, about what someone's done and the way they live their life and whatever they say and do, courts, as we are continually reminded, are courts of black letter law. Did you do something? Did you not do it? If you didn't do it, that's the end of the matter. Courts can't say, I have every sympathy with you, and invoke effectively the Scottish criminal idea of, well, you're not guilty, but it's not proven, which is a way of giving someone a slap, if I can use that expression, notwithstanding. That's what's really happened here. And all of Mr. Limbani's costs, because the judge decides that, well, you had something to do with driving the vehicle. One's bound to say, so what? Taking it on its face, he moved a vehicle on the face of it that he was asked to move, or whatever it was he did, and the judge did not find and make the important step, and I think you were part of the dishonest design, for want of a better description. So, my Lord, I'm grateful that you show it to me, and I'm grateful that you express your views on the point, but it doesn't get home what's actually happened here, but for all the reasons that I've adumbrated. I was going through some points. Again, this disclosure point, it's morphed. On the face of it, and certainly the way we see it, this disclosure and the way the language is used in the judgment, I'm going to say at best it's ambivalent. My learned friend says, well, actually, picking up your lordship's point, well, disclosure isn't just a formal disclosure under the CPR, it's also simply being upfront. That isn't, with respect, how it appears in the judgment. It talks about disclosure and non-compliance with orders, etc. In our submission, this was meant to be disclosure in the technical sense, which we know was wrong. It didn't happen that way. But even if it was, I make the point that I made earlier. So what? Mr. Carl was a man for whom trench warfare running up was part and parcel of the trial. He asked for specific disclosure against various people. There was never a stage where he asked for disclosure against us. And dealing with this discrete point, well, it was your wife's bank account. So what? Our wife is not us. I can't require my wife to disclose what's in her bank account any more than she can ask me to disclose what's in my bank account, assuming we don't have a joint account. And that's not any evidence they had a joint account. She got money in her bank account, not their bank account, her bank account, I think. Stand to be corrected if I misrepresent.
Yes, I think that's the basis.
It's her bank account. Well, as the law will know, I'm not being churlish about this or trying to be amusing, her bank account, as an external party, could have asked for disclosure of her bank account. And it doesn't fall on him. He's got no control over her bank account. It's her bank account. It can't be anything he's had in his possession because it's her bank account. So it's a bad point to say, well, as my learned friend was trying to push this point uphill, frankly, well, he could have disclosed what was going on in his bank. No, he couldn't. He's got no rights to. And if for some reason Mr. Carl, who was very thorough, it seems, in everything else he did, he could have gone beyond that and said, okay, I want everything in your bank account. I want anything to do with you or your wife. So it's not, again, it's not a fair criticism. And again, picking up something, my learned friend a number of times I think used the word fraud. It's easy for language to slip out sometimes on one's feet. And of course, I think at times you almost recognise it. But the whole point is, the judge didn't find a fraud. He could have done. He could quite properly, in the sense it was a matter for him to conclude as the judge of fact, that there was some dishonest design taking place. But he didn't. So trying to characterise what Mr. Limbani was involved in as a fraud, which was a word my learned friend used on more than one occasion, is wrong. Mr. Limbani was a man who was, for want of a better word, acquitted. He was a man who succeeded. And reason for not changing his mind. 50A. Trying to find, I'm looking for the supplementary bundle, which is not there, is there? Yes, and again, if one looks at what was colouring the judge's mind, I appreciate this court must have a discretion, it must be exercising effectively ab initio, but in trying to do that, it's got to look at whatever material it's got before it. But just to understand what might have been influencing the judge's mind, he's told us, if you look in the supplementary bundle, page 50, it's the judgment, it's the transcript. Top of page 50, letter A. When the judge is dealing with his provisional view, which has morphed into a final view. We know what influenced his mind. Judge Gleeson. Okay, well, I'm not about to revisit my judgment, which is that Mr. Limbani will not receive costs in the main proceedings because of his unwillingness to participate in them. That's the basis. Everything else, frankly, is fishing around. Anything that's not that. Maybe they were comments of the judge. Strictly speaking, they're obituary if they're not determinative of the issue in any event. But the sole reason he rules against Mr. Limbani was because he wouldn't participate. But in and of itself, that's not a reason not to give someone their costs. Just because you won't help the claimant make his case better against you or against co-defendants. That is a crucial point. Now we know why the judge decided against, and that's why we know. If that's right, maybe one had had a chance to address him on this. One might have been able to disabuse him of that's not a good reason. But we know why. And in our submission, when one looks at the authorities, as I say, it's tantamount to some kind of egregious conduct, or it's something that's connected with costs, but it's always connected with costs. It's not simply in and of itself bad behaviour. The judge identifies that, unwillingness to participate. What he doesn't do is say, as a result of which the claim was brought against him. It shouldn't have been. He lengthened the trial and da-de-da, etc. And in terms of perhaps, dare I say, how one approaches it, as I've said, we've lost the opportunity down below to make submissions. Ordinarily under CPR 44, the court will know, CPR 44.2, subparagraph 2, the general rule is costs follow the event. I'm entitled as a successful defendant to have the benefit of that. If it's going to be displaced, in effect, it's not for me, even with respect in the Court of Appeal, to try and say, this is why I should get my costs. It should be for the other side to say, this is why you shouldn't get your costs, or at least you shouldn't get all of your costs. I sense, but I don't want to address until the court presses me on this, that my learned friend might be, not only having conceded we might be entitled to at least a consideration of this, whether there is then this question of carving up, not that I heard any figure being suggested, but the learned friend effectively says at one point, nearly the end of his submissions, that what we are trying to do was hopeless, talking about challenging the judge's findings. Well, again, I didn't have an opportunity down below to discuss with the judge any of his findings, to disabuse him of either mistakes or anything else. And now we're in the Court of Appeal, whether we like it or not. We've got no opportunity to do so. But I am entitled to say I've been deprived of my opportunity to challenge findings, but the burden shouldn't be on me to say why I shouldn't get them. It should be to say, well, why should the other side not have to pay them? It's a different question, and it's more than a forensic point. It is, what is it I'm required to do? The way we see it standing here, my learned friend is continually making the point, well, the judge made certain findings which one might consider dim about your client, ergo, you don't get your costs. Well, with respect, that isn't actually how it works. In the ordinary way, had we been in front of a trial judge, my learned friend would have had to say, my lord, I know the trial went against my client, against this defendant. Nonetheless, I want you to disturb the normal order for costs for the following reasons. And that must apply still when this court's exercising its power. Finally, I think I need to just look at the Friday afternoon case involving the lady and the Donnellan, Warden Donnellan case. I've got just a couple of passages and then I will be complete. Yes, paragraph 49 of that judgment, Donnellan and Ward. Just going to take your lady and your lordships to a couple of passages. Paragraph 49, at paragraph 30 in the case referred to above, that's the Hutchinson and Neal case. Lord Justice Pitchford stressed the point that the fact that was the claimant had launched an action on grounds which failed. He pointed out the defendant's dishonesty was isolated from the issue upon which the claim was founded. It was not a case in which the grounds upon which the claim was brought was infected by that dishonesty. Well, as light follows day, whatever the judge thought about us, even if one pitches it as high as you were dishonest, Mr. Limbarney, you didn't tell me the truth. That did not infect the claim.
Well, it's a question of what perspective you're looking at. So if you say what you need to look at here is the party that the judge has found to be dishonest in this case is the defendant. His case was in his defence, was comprised in his defence, presumably his witness statement, which I see we now have. We do now have.
Do you have a copy of it? We haven't. I realise neither my learned friend haven't addressed you on it. But frankly, I should have said. I'm glad. If you look through it, there isn't anything in the witness statement in and of itself which ends up finding a way into the judgment. It looks like the points the judge made is probably made on cross-examination or other material. It doesn't appear to be anything that I can see in the witness statement. It's fourth because there was earlier witness statements in relation to other procedural matters. But there doesn't appear to be anything in that witness statement which ties in with any of the adverse points the judge makes. So the witness statement doesn't take us any further.
Okay.
And that's important because perhaps the witness statement was true. What the court found untrue was whatever he said in cross-examination.
But the point I'm making about 49 is this is a you have to look at in what respects the dishonesty was potentially relevant, and the case being put against you is that the dishonesty was relevant and went to the heart of the claim.
But we won on the point, my lady.
You won on the point in terms of level of... Yes, we know we've got that.
Well, so my lady, it's again, it's kind of a not proven, isn't it? Either the judge could, in the English system, it's binary. Either judge decides that some aspect of the honesty of a witness turns around so much so that he or she will make an adverse finding relying on some matter of dishonesty, lack of truthfulness, or whatever. The other way is what's happened here. The judge gives us some adverse comments about our evidence, but using that word, those parts of the judgment did not infect the claim. If they'd infected it, he'd have found against us. So we won. Putting it crudely, we're someone who the judge decided wasn't entirely truthful, if I'm being delicate, but notwithstanding our lack of truthfulness, he still didn't find that we were culpable of the civil claim brought against us. Is that sufficient, my lady? Or do I need to address you on that paragraph and phraseology more? Because it's an important point, and my lady's right to raise it, but actually that's entirely it. Did our dishonesty infect the finding? There isn't any part where the judge can say that, yes, it's what's caused our downfall, because in fact it had no bearing on the finding. And it's right for us to stress the point, because it's not unusual that, in this case, he seems to like whatever Mr. Carl says. Our learned friends took you to that, so that's fine. But it's not unusual that one finds cases where a judge takes a dim view against someone, but nonetheless just decides they haven't done whatever it is the claim says that they've done, or counterclaim for that matter. If I could move on to page, well, it's paragraph 59 with a quotation in the same judgment. And then after this, my lady, I've got one more, and then that's it. Down the bottom of the quotation, lifted from to what is on the Judge Hodge QC, as then would have been in the case of Ayuja Investments Limited and Victory Game Limited. The reference is over at page paragraph 56. And the judgment on Friday was quoting from the case. He went on to explain how he would put into practice the principles that he had identified. I quoted in full because it's an exemplary approach. I don't need to, unless the court wants me to, rehearse all of the extracts of 56, 57, but what I wanted to do was look down the second half of the extract from paragraph 57 of the judgment, quoted the Ayuja judgment. In my view, there should be an order for costs in the defendant's favour, subject to adjustments to ensure they recover no more costs than they would have incurred in advancing an entirely honest case, and adjusted to ensure that the claimant doesn't find itself bearing the cost of resisting those parts of the defence that were dishonest. Obviously, that's on its facts, but the point being that one looks at adjusting the proportionality, the fairness, the well-known overriding objective principles that we are all now familiar with in this case. Can we look at the judgment that was found here, and if we want to make an adjustment, in some way say, right, well, you've won, shouldn't have been brought against you. I know you said some things, but actually that didn't affect my judgment, because actually if they had really infected it or affected it, I could have made another finding, which I didn't. And that's really part of the test that's going on. What would be right to give to someone who has succeeded in a claim, notwithstanding some unfavourable findings by a judge against them, when someone brought them in, as we know, and one has to emphasise this, we know we were brought in to coerce us, frankly. Let's not mischaracterise what was going on. The claim was brought against us because Mr. Carl thought, by being the driver of these people, that he actually had some hand in the dishonest manoeuvring. My lady, I said one more point, and it's this. It's paragraph 67 of Friday afternoon's, whenever it was, Friday's judgment in the Donovan case.
Are we back to 67 of the actual judgment?
Yes, 67, sorry, of the actual judgment, yes, your ladyship's colleague's judgment. Again, the penultimate sentence rehearses the point about Mr. Donnellan's dishonesty in infecting the claims, as it were, and then it's the last sentence. This part of the judgment also leaves out of account the fact that none of the costs, including the cost of the evidence on the Ebenair issue, would have incurred if Donnellan had not chosen to litigate in the first place. Mr. Carl chose to litigate against it.
Yes, but you've got to bear in mind here, the context was that Mr. Donnellan made a dishonest claim. His claim was dishonest. It's been made clear to us, and I don't think you dispute the fact that Mr. Carl's claim was not found to be a dishonest.
No, it wasn't dishonest, but he chose a path that he didn't have to. He chose to sue Mr. Limbani because he thought merely being the driver.
No, we have that.
Then you've got the point.
Thank
Can I
you.
just turn my back one final time to make sure? Well, I'm reminded, I don't want to count my chickens. Clearly, if the court were with the appellant on the point, in one sense, the wind blowing in a certain direction, the one thing I think neither side has addressed you on, and it may be you don't need to or you might, is if we were right, even if there's either, because obviously judges, costs can be anything from 100% down to something above 0%. Neither one of us have addressed you on the percentages, almost into horse trading. I've deliberately eschewed that because I need to win the case first before I address you on that. But I'm conscious that neither one of us has addressed you on what might be the appropriate, clearly a number between 0.1 and 100.
Well, I think one of you is saying 0 and one of you is saying 100. So I think we have.
Well,
we are clear as to your respective
I don't want to fall into that. Okay, I just raised that because I'm conscious.
Yeah.
In the way I put it in my skeleton.
No, we're clear.
For obvious
we're clear
reasons.
That were we exercising discretion, in theory at least.
Can I say this then, and it's presumptive, but if on the basis I succeed on this appeal in some way, thank goodness, then I would say if the court is in any way minded to discount 100% of our costs, it's still got to do so on a justiciable basis. In other words, on the basis that there is something about what we've done which has, for want of a better expression, infected how we came to find it. That, I would say, should not be less than 50%. On the basis, I know it's splitting it. There is some of the cases I don't need to take you to them. You may recall where the court.
I'm not sure this is an appropriate point to raise in reply.
I was conscious that it's because my learned friend in response said for the first time, in effect, he saw which way the wind was blowing. So picking up on that, it seemed, and I just raise it as a courtesy. But I would say I'm just concerned that I have not had an opportunity to. If you come back and say you've won, but costs are going to be 0, 10, 20, I would want an opportunity to, if I needed to address you on it. Having seen what went on below when one didn't press the court firmly enough to say I'd like to make some submissions even if it's slightly uncomfortable.
Thank you.
Thank you. Thank you, my lady.
Well, at this time it won't come as a surprise. We will be reserving our judgments. Drafts will be circulated in due course to those whose names and details have been provided.
Yes.
That's for the purpose of drawing our attention to typographical and other minor errors, not for the purpose of re-arguing the case. We'd also ask that you take the opportunity to agree, if you can, a draft order. To the extent you can't, brief written submissions, please, with a view to finalising the order at the same time as hand down. I have to remind all those in court that circulation is on a strictly limited basis. I hope you're all aware of the Counsel General for Wales case. Circulation beyond the permitted list may well be a contempt of court. The court takes it very seriously. So it only remains for me to thank all those who've made submissions and those behind who've assisted them. Thank you.
Thank you very much.
Thank you very much.
All rise if able.